considered the argument of the plaintiff that the suit will be governed by Article 65 of the Limitation Act, and the period of limitation will be 12 years. The court recorded that the plaintiff came to know about the settlement in favor of the defendant for the first time in May 1979. And the cause of action as disclosed in the plea was that it arose on 15/3/1983 when the executive magistrate passed the order under section 145 CRPC declaring the possession of the defendant number 1 over the suit property. And thereafter there has been subsequent proceedings. And ultimately the criminal division was dismissed. The further cause of action was that in the month of January 1991, defendant number 1 had made an attempt to dispossess the plaintiff from the suit branch, and the suit was filed on 25/3/1991. The learned trial court ultimately held that the real invasion of the interest of the plaintiff arose when the plaintiff learnt about the settlement of the defendant number 1 in the month of in favor of defendant number 1, and also in the month of January 1991, when the defendant number 1 made an attempt to dispossess the plaintiff. The court calculated the limitation from the month of May 1979 and also January 1991, and since the suit was filed on 25/3/1991, it was held that the suit was filed within limitation by referring to Article 65 of the Limitation Act. The court also recorded that the threat of invasion upon the right of the plaintiff over the suit property was the cause of action. Issue number 3 and 4 were not pressed. The issue number 6, 7, 8 and 9 were taken up together by the learned first appellate court.
Separately, 6 and then 7, 8, 9.
6, 7, 8, 9. All were taken up together. Para 7. Trial court. the learned tried to by considering the oral and documentary evidence adduced on behalf of the parties, the court considered that before the LRDC Sarikela, a petition for cancellation was filed. Cancellation of settlement of defendant number 1 was filed, and the report was called for from the Anchal Adhikari. And report was submitted stating that the suit land was already settled with the plaintiff, and that the plaintiff is in possession of the property. And also that the defendant number 1 has got settlement of another property, via plot number 1174. But no steps was taken for cancellation. The court recorded that the defendant number 1 was not a landless person. He also had, as he already had a property settled in his name. And ultimately reported that the plaintiff has proved the settlement parwana. The plaintiff himself was examined as PwC. While considering the evidence of the defendant, the learned court recorded that altogether 9 witnesses were examined. Out of them, defendant DW 1, 3, 5, 6, and 7 were formal witnesses. DW7 is the defending witness number 1 himself. The learned court after the learned court also recorded that There was much weight in the argument of the plaintiff. The witnesses of the defendant were from different village. And they cannot be the complainant in connection with settlement. The plaintiff witnesses were belonging to the village where the school property was situated. The defendant number 1 had also taken settlement of some portion of lot number 1174, dated 2 December the year 1970 from the state of Bihar. The court recorded that by considering the exhibit 1, the court recorded the submission of the plaintiff that there was seal and signature of the authority who had issued the parwana. Exhibit 1 to X/2, and Exhibit 1 showed that parwana was issued to several persons and no seal was given on Exhibit X to X/2. And Exhibit 1 showed that there is seal and signature of the officer who issued the parwana. The court recorded that Exhibit 1 was proved by PW2 and PW7. It was submitted by the counsel for the defendant that Exhibit 1 parwana was issued by BDO and the same was not issued by the circle officer. PW7 had stated that BDO Chiranjeev Jha was also the in charge of the circle office Kachari in the year 1970, and BDO was also doing the work of the circle officer, and there was no separate seal of the circle officer. The learned court referred to Exhibit 2, which showed that the parwana was issued to the plaintiff in the year 1970. And the increase of patta was not challenged by the plaintiff. And the parwana issued in favor of the plaintiff was earlier reported. The learned court recorded that it was well proved that parwana with bracket Exhibit 1 issued in case number 35 of 7071 was by lawful authority. The court recorded that, except dependent number 7, the other witnesses of the dependents were not from the same village. The learned court also considered that the plaintiff's witnesses were belonging to the same village where the suit land was situated, and they have got the land area, they have got land near the suit land, and these witnesses had supported the case of the plaintiff, and ultimately held that the parwana issued to the plaintiff dated 5/9/1970 and settlement case number 35 of 1970-71 was proved by Exhibit 1 and also by oral evidences. Exhibit 1 and Exhibit 2 and also by oral evidences. And held that the plaintiff is entitled for his rightful title, and that defendant number 1 had not acquired any right title and interest over the suit land by means of the settlement dated 30/6/1975, as the suit land was settled with the plaintiff in earlier point of time, and there has been no cancellation of the settlement in favor of the plaintiff. Settlement bill was made in favor of the plaintiff. The learned court thereafter recorded that from the perusal of Exhibit E and E by 1, C and E, page number 24 में, bottom में, it transpired that the defendant was in possession of the suit land, but the defendant number 1 had got no locus standi to remain in possession, as they did not have any right title and interest over the suit property. And ultimately, the court decided the issue number 6, 7, 8, and 9 in favor of the plaintiff and against the defendant. And declared the settlement in favor of the plaintiff as valid and the settlement in favor of the defendant as illegal, and directed the suit was decreed with loss with the direction with the decree of recovery of possession in favor of the plaintiff. So far as the first appellate court is concerned, same issues were taken up for consideration. By considering the point of limitation, the first appellate court has limitation and cause of action. The first appellate court has decided the same by paragraph 17 and was of the view that the suit was covered by Article 58 of the Limitation Act, and therefore the period of limitation would be 3 years from the date the right to sue accrues. And the learned court was of the view that it was the court also observed that it was admitted case of the plaintiff that it was admitted fact that right to sue to the plaintiff accrue either in 1979 or 25/5/1980, and being computed from this period, the suit ought to have been filed by the end of 1983. But the suit was filed on 25/1991, and therefore the suit was barred by limitation. The with respect to issue number 6, the report which was relating to settlement of Khata number 167, plot number 1174 in favor of defendant number 1 in the year 1970. The learned court was of the view that the learned first appellate court was of the view that this issue was not required to be framed. And the same appears not to have been denied by the defendant. And therefore the court was of the view that there could not be any difference of opinion from the one given by the learned trial court by paragraph 17 and 21 of the judgment. Meaning thereby that the settlement of Khata number 167, plot number 1174 in favor of defendant number 1 in the year 1970, though it was not the sole property, stood admitted in the records. So far as issue numbers 7, 8 and 9 are concerned, the same were taken up from paragraph 6 onwards of the trial court judgment or the appellate court judgment. By the reliance on exhibit 1 by the plaintiff was specifically considered by the first appellate court by paragraph 8. The court was of the view that the plaintiff claims settlement by Parwana Exhibit 1 dated 16/8/70 and the evidence of PW2 was to be analyzed. Who had proved the document? PW2 had deposed that it contained it was in the writing of Mohan Saw clerk and bears the signature of Jharkhand Jha. And Jharkhand Jha, and he has also stated that Jharkhand Jha was the video. Chiranjeev was the video and was in charge of the circle. The court also considered the evidence of PW7, the plaintiff himself, who has stated that the Parwana did not contain the signature of the officer concerned and was only stamp of the office. The court ultimately reported that the court did not find the signature of the issuing authority, that is a circle officer, though a plain seal was affixed there. The court discarded the evidence of PW2 by paragraph 9 by stating that he was only 13 years of age at the relevant point of time and he could not have recognized and identified the signature of video Jharkhand Jha or the writing of the clerk Mohan Soy in the settlement Parwana dated 16/8/1970. Nor he was an eyewitness to that, not he could be said to be an eyewitness to that, not he was a government servant working in the office. The court also recorded that the clerk Mohan's soil was still surviving, but what prevented, but he could have been called upon by PW7, the plaintiff, to throw light on the sanctity of the settlement Parwana Exhibit 1. The learned court thereafter discussed the findings of the learned trial court and observed that the learned trial court was of the view that PW2 had proved the settlement Parwana, but no reason as such was assigned. And observed that the evidence of PW2 was wrongly relied upon by the learned trial court. It was also observed that the defendant had specifically denied the issuance of settlement with respect to the suit property in favor of the plaintiff by stating that no ishtihar or publication of any kind was made prior to settlement case number 35 of 1771, which led to settlement in favor of the plaintiff on 16 in 1970 by the settlement Parwana Exhibit 1. The court referred to Section 101 of the Evidence Act to say that the burden of proof of the fact rests on the party who asserts it. The learned court ultimately recorded that the plaintiff has not been able to prove the Parwana settlement in his favor. And has not even proved the settlement proceedings initiated in his favor through official records. The proceeding were the court held that on such premise, the settlement Parwana Exhibit 1 cannot be said to have been settled in favor of the plaintiff, as the plaintiff has failed to discharge his burden of proving his best claim. And on the basis of evidence of PW7, the said document cannot be said to be a genuine one. We need to rise now. फर्दर का लिखाएंगे, ठीक है? आपको बहुत क्लियर लिखाएंगे। सेकेंड हाफ में आप काम करते हैं, ठीक? फर्दर